The 21st Century Road to Housing Bill became law. Many people think our work is over, and as we're going to talk about today, our work is actually just beginning. January 2027 will be here before we know it.
We know the what and we know the when. We just don't know the how and the where. It behooves anybody who may be affected to start collecting the information, getting themselves organized. You have to assume this is going to be live on the 7th, so be prepared as far down the road as you can.
The first thing that you need to do with Road to Housing is you have to read the bill. We'd be amazed at how many folks who are impacted by the legislation never actually take the time to read the bill that's going to be governing everything they do moving forward.
Capital was just frozen for about 6 months. Many of the buyers were coming in and canceling their escrows. They were just saying, we don't know what this 7 year is going to look like. People couldn't sell their built-to-rent product.
I'm just a third-party manager. I don't own the homes. We don't believe is an easy out. You really need to treat this like you own the assets and be the administrator well.
Good to be with you. I'm Gregory Frank, and this is Everresi Media. Over the past several months, our Executive Order panel series has followed the 21st Century Road to Housing Act from proposal to passage. On July 11th, it became law. Today is our first analysis since. But while the headlines are over, the real work is just beginning. Understanding what this means for how the SFR BTR industry builds, invests, and operates. Today, we're breaking it into 4 parts. The facts, who's actually regulated, the operations, what changes on the ground, the unresolved questions, where the bill goes quiet, and where BTR goes from here. Joining us are some of the industry's leading experts to separate fact from speculation. Our discussion is moderated by longtime industry executive and Everresi Media contributor, Cheryl King. Cheryl, welcome. All right, Cheryl, we'll toss it over to you. You've got an esteemed panel with you. Let's get into it.
All right. Thank you, Gregory. And it's my pleasure to be here today with you and with this esteemed panel. As you mentioned, the 21st Century Road to Housing Bill became law. Many people that we've talked to think our work is over. And as we're going to talk about today, our work is actually just beginning. January 2027 will be here before we know it. There's Congress has its summer break, we have holidays, and so there's a lot of work to get done. I'm very excited about our panel of industry leaders and innovators in BTR, policy development, and property management. So we have a lot to unpack today, so let's get started. David, please kick us off with your introduction.
Sure, thank you, Cheryl. Glad to be with you. Always appreciate joining Everresi for these webinars. I'm David Howard. I'm the principal and founder of a Washington, D.C.-based lobbying firm, Real Estate and Housing Advisors. I work with clients primarily in the SFR and BTR space on issues of policy, both at the federal level and the state level. As you might expect, 125% of my time over the past 6 months has been devoted to the Road to Housing Act. So happy to discuss it today. Looking forward to joining the others on the call today as well.
Thank you for all your efforts. I know it's been a long year. Greg, tell us about the NAA.
Yeah, thank you, Cheryl. It's a pleasure to be with you today. My name is Greg Brown. I'm the Senior Vice President of Government Affairs with the National Apartment Association. We are a federation of 139 state and local apartment associations around the country, and we represent everyone from the smallest owner-operator to the largest firms in the business that are engaged in rental housing of all sorts and all segments. So conventional, affordable, BTR, students, all the different variations and permutations in between. I lead the advocacy team here at NAA, and like David, have spent a lot of time over the last 9 to 12 to 18 months, depending on how you look at it and how you count the math, working on this very important piece of legislation. So very excited to be here and be part of the conversation.
Thank you for joining us. And Travis, it feels like, back in the early 2000s when SFR wasn't even an asset class and we were literally building the plane while we flew it. So welcome to the panel today.
Thanks, Cheryl. I'm Traves Bonwell, the CEO and co-founder of Renew Property Management. We manage nationwide a range of assets from single-family scattered, build-to-rent communities, and multifamily. So we're looking forward to discussing how we'll operationalize the bill.
Todd Wood with Christopher Todd Community. We've been developing, building, buying, financing, and managing cottage-style BTR for over a decade.
Awesome. Well, thank you. So let's begin with talking about some of the ambiguities in the bill. David, I think one of the questions that we all have on top of mind is how are we defining a large institutional investor? If you could kick us off with that.
Yeah, I think the answer, unfortunately, is it depends, which I think fits nicely into your lead-in. Speaking of ambiguities, on its surface, the bill is fairly straightforward in terms of its definition of what a large institutional investor is. If you own 350 properties, single-family properties, that is, defined as a structure with one or two units, you pretty much qualify. However, when you start to peel it back, and when a lot of companies start to think about how they're structured, how they're owned, who their investors are, where they invest, how they invest, when you start to peel away all of these layers, you start to realize that there's actually a lot happening beneath the surface that impacts whether, in fact, you are subject to the definition of large institutional investor vis-a-vis road to housing. For example, I have some clients who, for all intents and purposes, you would think would meet the definition of LII in the bill. They're institutional, they have relatively large footprints, relatively sophisticated investors, but because of some nuances in the bill, they actually don't meet the definition. So they can kind of skirt around the bill and the provisions therein. So, again, on the surface, the definition is fairly straightforward: 350 properties or more, single-family homes, one or two units. But again, you really need to think about and understand what's in the bill and how you're structured and what your strategy is and what your focus is, because again, there is a lot of nuance in there. There is a lot of ambiguity. And I tell clients the first thing that you need to do with road to housing is you have to read the bill, which I know sounds very, very simplistic and obvious, but first of all, you'd be amazed at how many folks who are impacted by the legislation never actually take the time to read the bill that's going to be governing everything they do for time moving forward. And so the first thing that I counsel clients to do is read the bill, understand what's in it, understand how your business will be impacted, understand how your business partners, how your investors will be impacted by the bill. Because again, contrary to how the bill is being presented, either in the media or on Capitol Hill or elsewhere, there is a lot that goes into the bill to make it kind of a quirky piece of legislation that impacts a lot of owners and investors in different ways.
Well, and I thank you for that. And it was interesting. I think there was a nice segue to Travis. We're going to talk in the next segment a little bit more about operationalizing, but the bill or the act defines it as 350 or more in concert with others. And I think, Travis, you have an interesting perspective on how we define that as well.
Yeah, our view is that because we're a third-party manager, we still have discretion over our clients' assets to some extent, as well as we're acting in concert with those entities. So we're going to take an approach to include in leases, renewals, as well as a one-time initial notification to residents on the new HUD resource. So we're going to take the burden and try to navigate that gray and say we're operating in concert as well. So we should notify residents of the resource, and then allow our clients the ability to have us do that for them, or at least view through our system that it's been done and on record.
Thank you. And Greg, I know you've been watching this from a government affairs seat with the NAA, so love to have your thoughts on, this definition and how it applies as well.
Yeah, let me start by saying, of course, as I do every time I have one of these conversations, that nothing I'm saying is intended as legal or operational advice. And the first thing we tell people is you need to talk to your attorney. And so, of course, as David pointed out, the act says one thing, the interpretation by each individual firm, like Travis has, and a very individualized set of circumstances around their ownership structure and the relationships they have with their counterparties, et cetera. That all needs to be worked through with an attorney. But the other thing that has to happen here is the Treasury itself has to provide guidance for the industry about how to operationalize some of these things. So, while the Act says ownership, primary investment, management authority, GP, management member control, more than 25% equity control, passive, all these sorts of things are in the law. Again, Treasury needs to kind of opine about this is exactly what we mean and answer some of these outstanding questions. And that process is now underway. Because as you point out, Cheryl, it doesn't stop just because the bill became law. Now there's a whole nother mile of work that has to be done by not just Treasury, but HUD and some other agencies to really put all this into practice. So we'll be watching very closely that process and engaging with all of those departments to make sure this is done right. And we're going to talk, I think, a little later about this kind of outstanding nuanced issue, like David said, nuanced issue in the language around BTR and subsequent sales of properties to make sure that gets dealt with adequately by the Treasury and that confidence in the marketplace is still there.
Yes. Well, and I'm happy to hear you mentioned that conversations have started with the Treasury.
Yes, they have.
I'm sure. Okay. I would have thought it would have been a much longer timeline before they thought about this. Just being an outside observer, not connected like you and David are.
Yeah, no, I think that there were folks that I've spoken with who were having conversations before the bill become law because we're all optimists that the bill was going to become law, no matter all the machinations that happened around that. But now we begin those in earnest, and they're starting this week with our coalition partners and others to try to weigh in on this stuff. And I think it's important for confidence in the market, right? The market needs to know that as the bill is written, exactly what this means, and we can begin with the new investments or continue investments that we may have put on pause or whatever else might be happening in the market. So it's important that they move quickly, and I think they understand that.
So we've talked a little bit about who's covered by the Road Act, and I'd like to spend some time now just talking about how we operationalize this, because I think all of you have, a lot of great information for people really on just the next, path forward and the short timeline that we have. So, Travis, would you like to start the conversation? And then...
Sure. Depending on the clarity that Greg and David alluded to from Treasury around is a third-party manager operating in concert with the institution. We're planning as if the answer to that's yes, and we view that we need to be responsible for three things, and those are in motion now. One, an initial notification to all residents of the HUD resource that's to be built, the website and the phone number, and that this home is owned by an institutional investor per this legislation. Two, like the lead-based paint notification for homes built older than 1978, this will go into all new leases as well as renewals. So this will be a standard insert to every single lease and renewal. Most property management software systems will easily be able to handle that. But I would say where you've really got to make sure you've got the tech stack and ability to surface any sort of concern. So we're opening up a website and a phone number for any resident to, voice a concern, whether that be with their lease or maintenance or fees or whatever. We need to make sure we can ingest those concerns quickly and surface those to a proper asset management, resident relations, and leadership team, not just allow those to be delivered to anyone in the company. Those really need to go into a system first and handled, appropriately. All the notifications would need logged and an audit showing that the resident's been notified, so that when a concern may come in, you can show that you've notified the resident. So I think we're trying to, we have a tech stack that will enable us to handle those concerns well. But I would say the key component of I'm just a third-party manager, I don't own the homes, we don't believe is an easy out. You really need to treat this like you own the assets and be the administrator well.
That's an interesting perspective that I hadn't thought about, just the need to even just modify all the leases and the lease amendments to notify the residents. David, we'd love to have, your perspective on, there's the requirement, I think it's for the resident or the renter outreach resource. How do we see that tying into, what Travis was just talking about for property management?
Yeah, and just to follow on to something that Travis mentioned and that I commend him for, there's not a lot of time here. To some degree, as an owner, operator, investor, builder, you kind of need to move forward on faith. You have to read the bill. You have to try to understand the bill to the extent that you can. Obviously, all of these owners and investors know their business. They know what they're doing, but you have to try to figure out how that will be impacted by the bill. And you have to take a lot of that, or at least some of that, on faith, because as Greg pointed out, we don't have the regulations in place yet telling us how to do that, telling us how the language in the bill will in fact be interpreted. And like Greg, I actually think Treasury is doing a pretty good job. I've been through this. I know Greg has as well. I've been through this several times during my career when a bill becomes law and then it moves to Treasury and regulations get. Sometimes these things can take not just months, but years. You deal with preliminary regulations, you deal with final regulations, you deal with amended regulations. The fact that Treasury is already moving this process forward, I think is a very positive thing. And I think it speaks to how seriously and committed they are to the process. But again, there's really not a lot of time here to stand around and kind of wait for those regulations to come out, because within the next 6 months, there's an awful lot that has to happen. HUD has to come out with its renter outreach resource program. Companies have to comply with that program. There are certain things that they have to hit. They have to report to HUD on the effective date, 180 days after the date of enactment, that they are in fact an LII. If they do meet the definition, they have to provide a count of properties broken down by city and state. So there's a lot that actually has to happen between now and January the 7th. And then don't forget, you've got a big election in November. You've got the holidays shortly after that. So there's a lot that's kind of coming at us very quickly. And there's a lot that could get in the way. And so I think companies really are going to have to keep their eye on the ball and move forward with perhaps a couple of different contingencies. What if this happens? What if this provision is interpreted that way? I don't think companies have the luxury of dealing with things after the fact. I think they're going to have to prepare as best they can and move forward. And there is legal counsel out there. There are people like me out there. There are trade associations like NAA who are here to help in that process. But again, I think that the big risk to any company at this point in time is not moving quickly enough or not moving at all, thinking that these regulations are going to be coming sooner than they probably will, and that companies will in fact have time to respond to them. So again, a long way of saying I think companies need to take a more proactive stance here, really engage with the legislation, try to understand it to the best they can, figure out how it's going to impact their business and move forward. Because again, January the 7th is going to be here before we know it.
I agree. And I think as Travis was mentioning, the operators, the property managers needing to track the resident disputes, there's also the component with the HUD website, correct? The resource center. So tracking I would assume what happens is the resident has the option to go to that resource and place, a concern, and then that will be sent back to the property manager or the operator. So they would probably need to track that as well. Am I thinking about that the right way? And then
you are for sure. And again, in terms of the renter outreach resource, there are a number of very discrete steps that companies have to follow that are pretty straightforward in terms of the language of the bill. You have to, as a company, you have to have an infrastructure set up. You have to have points of contact. You have to provide, as Travis mentioned, you have to provide information to your residents so that they know how to file disputes, so that they know who to contact in case they have issues. And so, again, there is some ambiguity in different parts of the bill, but there are also some very specific provisions and compliance components to the bill that do allow companies to move forward. But again, moving forward is the key phrase, because there's just not a lot of time here. And then the other difficulty, I believe in terms of the renter outreach resource at HUD doesn't really have to come out with this until the effective date, until January the 7th. And so if you're a company, you kind of have to wait for HUD, obviously, to build the mousetrap and get it out there and let companies know how they can comply and what all the various steps are. But again, I think there's a real risk as an owner or an investor or operator to wait until that actually happens. So again, you kind of have to take a little bit on faith and try to move forward in the best way possible here.
Cheryl, if I may, I think you might characterize it, one way to think about it is we know the what and we know the when. We just don't know the how and the where. So how is HUD going to specifically drive people to do these certain things? And where are they going to send people to file this information, to submit this data? So I completely agree with David that it behooves anybody who may be affected to start collecting the information, getting themselves organized, going through the due diligence internally that Travis mentioned already, and getting as far down the road as you can on that faith that David noted. And then as soon as we learn the where and the how, you're in a good position to comply. And I don't think we should assume that, oh, there's going to be a break given because HUD took longer than it thought. You have to assume this is going to be live on the 7th and you're going to have to comply. So be prepared as far down the road as you can. And when HUD says, okay, here's the portal or here's the place, and here are the more specifics of how we want you to do it, you can activate on that. I think it just makes good business sense to do that.
We have drafts already started that are waiting to insert website and phone number.
There you go,
and
yeah.
We're assuming that will land on as late as January 6th for a January 7th deployment. So that's part of the faith element, like have those ready and be ready to notice once you understand the where.
Well, and even the form of notice, I would think, is probably, a big question mark. What satisfies the requirement? Is it email, or is it, will a text message work? Is it, certified mail, like snail mail, like probably just starting from there. How do you notice them? And it's great that you have a plan in place. At least you can say, here's how we did it. Well, and then there's also the reporting, the separate reporting requirement of the owners, right? Like maybe someone can talk about this, like the city, state, composition of their portfolio. I think that's of interest too.
Well, I think David described that quite well, and that you basically have to inventory what you have and where you have it. And it does get into some of that we discussed before about how you determine, are you captured by this because of the way you're organized? That's a pretty in-depth conversation with your attorney about figuring that out. But in creating that inventory now and just building that list, if you will, oversimplify perhaps, but building that list and then being ready to push it to wherever the department tells you to push it. And again, probably over providing is better than under providing in some cases, because it's better to be giving a little bit too much than not giving enough and then getting dinged for it. But again, we have to wait and see what the requirements are from the department. I think there's ways to get ahead of it, and you should try, for sure.
And then to that, Cheryl, I might also add, sort of before you're required to actually report to HUD, which is going to be somewhere around January the 7th, 180 days after the date of enactment. On the date of enactment, the date of enactment is also important because it kind of captures those properties that I believe are eligible to be traded in perpetuity amongst large institutional investors. I've had a number of clients on the build-to-rent front, and it would be interesting to get Todd's thoughts on this. I've had a number of clients on the build-to-rent front come to me and say, what qualifies as a completed home for purposes of identifying properties on the date of enactment? For example, I have one client who had a couple of projects in process that basically just stopped because investors were spooked by road to housing. And so they have land that has been entitled, they have approvals. In some cases, they've got homes where there are foundations that have been poured, but these homes aren't occupied. In many cases, they're not completed. But again, for purposes of defining a home, does that count? Do I have 5,000 homes, or do I have 5,250 homes if I throw everything into the pot? I mean, so there's a lot of ambiguity. Getting back to your earlier question, in the bill in terms of things like that. Now, for purposes of build to rent, and we can talk about this all day long, it might not matter because I think build to rent is going to be fairly well exempted from a lot of the provisions in the bill anyway. But when you're taking that inventory, as Greg mentioned, you need to know what counts. You need to know how to count your properties and what goes into the mix. And because there's some ambiguity in the bill around things like that, it could be hard to do. And then when you think about the fact that you've got single family detached homes, you've got duplexes, you've got triplexes, you've got cottage properties in there. It can become very complicated very quickly. Just again, in terms of figuring out what your inventory is as of a point in time.
Well, and today we're focused on, the road to housing, but there are also states that are being very proactive, right? So, David or Greg or Todd, would you like to talk about that? I think that's something that we don't have time to really dive into today, but I think it's worth mentioning that it's not just how we count this at the federal level, but there are some states that are very proactive with their own version of the Road Act. So
states can inspire the feds to act, and the feds can inspire the states to act. And so what Dave is describing in Michigan, there have been other proposals on institutional investors for several years now, actually before road was even gaining any steam, that we're already dabbling in this area through different tactics, different strategies, but definitely playing in this space. And so I think David's right. You'll see more of that, and it'll be up to affiliates like NAA and other organizations that have state and local affiliates to really work through some of that and try to mitigate or outright prevent some of the more egregious examples that are out there. Sometimes in some states it's really hard because this issue, and we could spend a whole podcast just on this, but this issue polls quite well. And there's a populist element to it. And so for those reasons, I think you're going to see a lot of this activity. And so it's not just at the federal level. This is not a ceiling, or not a ceiling. It's a floor in many ways. And so we're going to have to play a hefty role at the state and local level too.
interesting. I hadn't really thought about the impact at the state level, so appreciate the insights from both of you today. And Todd, one of the exceptions from purchase are resident-focused programs, the first looks, the 30-day. Bridge Tower, I believe, announced about a month ago that they're going to start offering some of their homes to their residents. Just curious as we, think about how we define institutions, if you see that, those types of resident programs will become more popular, or is it just maybe a check the box for compliance?
You're talking from a compliance, moving them from renter to owner.
Yes.
Well, we're talking about, as I always say, horses and zebras. They're two different animals. And when you come in with an investor that wants to buy or own and manage and operate a BTR for rent product, they're not looking at trying to transition them into a for sale. A lot of times if they come in and they're buying a single plat, that means you would have to condoize that plat, and that's usually after at least a 10-year period. And investors are buying this for rental investment. So it's, I don't see that as being a strong momentum from investors that are buying for rent product. The for rent product they want to hold for long term, or they want to turn that and sell based upon rental, not for sale. Now, we're in conversations with a number of builders where we can provide what we call a coupon or an incentive, that if they rent at a Christopher Todd for a period of time, we give them a coupon and they can go down and buy a for sale product at the local builder. So that's been a good program that has helped people transition into, for sale. But, going back to home ownership, it's still, this bill is trying to, I think, blur the lines of, people are going to rent and then they'll just fall right into home ownership. There are a lot of people that just don't want home ownership for a number of reasons. And I think we've talked a lot. There's this huge demographic shift happening in America that are preventing people from wanting and desiring home ownership. They just don't want it, and they'd rather rent.
Yes, thank you for that perspective. I thought it was interesting. We received some relief when the 7-year sale mandate was removed for BTR, and then they put this accepted purchase in. So I wasn't sure, what the thought process was behind that. If there was maybe some sentiment from, production builders maybe to include this, but I just thought it was very interesting. So, and I think that perspective, Todd, like investors invest for a specific purpose. If it's rental, it's rental. If it's for sale, it's for sale. And trying to blur those lines can be complex, especially as you said, the renters, it's not like the early 2000s. They rent by choice now. It's a lifestyle. There are days when I'm sure all of us think about that too. When there's a big maintenance request, it looks pretty inviting. So Todd, in terms of, the lifting of the 7-year sale mandate under the Road Act. I'd love to hear your perspective on how capital is starting, or if they're starting to unfreeze. I've talked to so many who were shovel ready, and the financing was paused until the bill became law. Love to hear your perspective on what you're hearing about the impact of the removal of that 7-year sale mandate.
Yes. One, there's this, we're going to call it the unclogging of a capital pipeline. Capital was just frozen for about 6 months. In fact, we had a number, we stay close to a lot of the brokers that are in the for sale of build to rent. And they were telling us that many of the buyers were coming in and canceling their escrows because they were just saying, we don't know what this 7-year is going to look like. So we don't want to implicate ourselves at a future transaction down the road. So they were canceling transactions. So people couldn't sell their build to rent product. Second, we had a problem where Freddie and Fannie was coming in and they were not even bidding on any of these transactions. And so all of a sudden you had buyers that couldn't get good rates through Freddie and Fannie, through institutional financing, that the agency financing, so they had to go somewhere else, and then the deal wouldn't work and they would back out. The other problem that I think happened was from a perspective of development. All of a sudden you had these developers sitting saying, okay, if we're going to start our development pipeline, and all of a sudden all the buyers are starting to fall out because of this 7-year hold or 7-year requirement to sell, they stopped. And so everything just froze for that period of time because of that obligation requirement that they were putting in on the bill.
So are you starting to see, some of the financing, come back to the marketplace, or is it still too soon?
Well, a good indication was last week, Stephen Scherr, president of Pradium, was on CNBC. And in his interview, he said that with the bill passing, at least we have some clarity that now institutional capital can start buying and being infused into BTR. I mean, that was a good indication. What we're starting to see, at least there's some clarity. One of the things we're hoping to see is that Freddie and Fannie has some definition on what they can and cannot do, and they can now start offering their financing to buyers. We're looking for that. We're seeing from an institutional, they're still not sure. I know David was trying to stay positive about saying, let's just move forward with faith. Okay. Faith gets you into trouble a lot of times. And so, everybody is still kind of on the sidelines waiting to see how this is going to roll out over the next 6 months. So we look at the next 6 months, it's still going to be, there's going to be a lot of headwinds. It's going to be a little bumpy until we all kind of settle into what the interpretations are. And then we think capital will start moving forward, open up, quite aggressively in 2027.
Perfect. Well, and Greg or David, this is a good segue to the letter that was just sent to Treasury around this definition of build to rent. So would either of you like to expand upon that a little bit?
Well, I'll start with just the issue. I'm sure David will have plenty to say in addition. I would say that the question on the table is someone able to, after a purchase, able to be an accepted purchase for a subsequent sale? So is that subsequent sale still covered under the provisions of the law? And so the way, not to get too granular, but the way some of the language is written, it's sort of a soft question mark there. So the industry, NAA, a number of other real estate organizations sent a letter to the Treasury trying to make clear that our read of the law and our read of a congressional intent is that that is the case, that BTR is always accepted as it is written in the statute, and that that subsequent sale is still eligible for the protection of the law. That said, I think you've heard this, Cheryl, and there are others in the industry that I think are just a little, and this is to Todd's point, Todd's very good point, that we need to have absolute clarity here, and the Treasury's role is going to be so important to provide that and to make sure that that is made clear. We've asked them in that same letter to move with speed to notify the industry, to put something out saying, we agree that this is the way that, they agree to our interpretation. They're going to make their own announcements, of course, but that they agree that that's the right interpretation, and to make that with as much deliberate speed as possible so that the market is given confidence. Again, to Todd's point, without that, I do worry that some in the market will say, I'm just not completely sure here, and that will have the same chilling effect that the 7-year for sale had during this whole process. So I know that they are reaching out. It's not just us reaching out to them. They are reaching out to providers in the industry, in the BTR space. I've heard that. And so that's good news. They want to understand this. They want to learn. They want to make sure that they're doing it the right way. So we'll take that as a good sign and hopefully have a good outcome. But I defer to David on other parts of this that he's hearing about.
I basically concur with Greg. I mean, look, my own interpretation, my own reading of the bill, which that and a couple of dollars will get you a cup of coffee down at Starbucks. I think build to rent generally is going to be a big winner coming out of the bill. Again, my reading of this particular issue is that essentially new product, new dedicated rental communities build to rent essentially will have a lifetime exemption from the prohibition on purchasing single family rental homes. Again, that's and I say that not because of the language exclusively. Having worked with a lot of policymakers and staffers on the Hill, and nobody's done more of that than Greg, of course. I kind of have a sense, I think, for the intent of the bill, and the intent really is not to choke off new construction. I really believe that. If you talk to people like French Hill, chairman of the Financial Services Committee in the House, and some of the other lawmakers who were very involved, even on the Democratic side, again, both in the House and the Senate, the intent here really is to allow industry to build more housing. And back to your question about the 7-year disposition provision, it just didn't make sense on the surface. I mean, for those of us, kind of in the trenches, it was hard to see. Hindsight is 20/20, right? But even back in the early days, it was hard to see that was going to stick, just because it was so counter to everything else that the bill professed to accomplish. And so, again, as far as this particular issue is concerned, my expectation is that Treasury will come out with some pretty clear language that gives build to rent what will amount to a lifetime exemption in terms of the prohibition on purchasing single family rental homes. And I think that's the right policy. I mean, you would expect me to say that, obviously, but again, I think in terms of what they want to accomplish with this bill, that certainly supports the cause.
Well, we're coming close to time, so I'd like to give each one of you a few minutes. If you could look into your crystal ball, just from your perspective, like what we need to focus on as an industry between now and January 7th. Travis, would you like to start?
Sure. I'll kick us off, and it's similar to what I stated before. We're now drafting notifications that are purely drafts and inserting into our process, ways to receive information from this to-be-built site. So I think that's what, from a PM operator perspective, get ready to make a lot of outbound communication and data transfer. We will take the approach of oversharing. say it's a build to rent that's scattered asset, but it's never been for sale, and like let's overshare that and just make sure we get off on the right foot on January 7th.
Greg, would you like to go
Sure.
next?
Yeah, I'll kind of reiterate some great points that David made earlier, that even though we don't have all the moving parts, we don't have the answers to every single question, follow the example that Travis is describing. Do as much of your homework now as you can based on what you know, based on what your counsel is telling you, and the interpretation based on your individual circumstances as a firm. I'd go one step further and say, share that experience with, if you're a client of David, share it with David. If you're a member of NAA, share it with me, but share it up to us, because we are having these discussions with policymakers. And if you say, look, this really has to be answered, or so I'm not going to be able to do this, or the burden of this is going to be extraordinary. So please, highlight those things, elevate those things so that we can inform the regulators, and later on, if need be, the Congress, that this thing has been created, and we've discovered that it's also created an inadvertent issue. Then we can try to solve for that. But the important part is to share that experience with groups like NAA and folks like David, so that we can do that advocacy on your behalf and make sure that all the relevant parties that are making these decisions understand how this is being implemented and what some of the hurdles might be to compliance.
Maybe I'll throw my hat in the ring. I think my advice for owners, operators, investors, builders in this space over the next 6 months would be, and maybe this echoes a lot of the comments that have already been made. It's time to get in shape. This isn't business as usual now that the bill has passed and is behind us. The bill, in my opinion, could have been a lot worse for industry, but the bill does allow for a lot of things, and I think if you understand what's in the bill, if you understand what the bill allows, I think that there is opportunity. Again, I think build to rent is going to be a big winner. I think we need to wait and see how some of these regulations play out. But again, I think long term, 5, 10, 15 years, when the bill sunsets, by the way, I think build to rent is going to be a real winner. But I think in the short term, over the next 6 months, the effective date isn't until January the 7th. For the next 6 months, maybe companies should think about being opportunistic while you can, before a lot of the layering of the legislation impacts you. And then keep in mind, for 2 years after the effective date, for 2 years after January the 7th, companies can still do business, LIIs, I should say, can still do business with non-covered owners and non-covered investors. And so, again, instead of looking at this bill, and I counsel my clients all the time on this, instead of looking at this bill as a long list of things that you cannot do, think about it instead as a document that provides sort of a roadmap for moving forward. It sets some guardrails on what you can and cannot do, but it does provide a path forward. But again, I think you have to do that in a way that is smart, and I think you have to do that, obviously, in compliance with the bill and what's in it. Again, a lot we're not going to know until we get these regulations from Treasury and others. But again, there is enough in here, I think, to let companies get a head start to the extent that they're ready and willing to take this on.
Well, and I'm glad you mentioned that. You said earlier, David, about the importance of reading the act. And I actually did sit down last week and read Title 10, and it was very fascinating to me. But as you just mentioned, there are some great opportunities built in, such as purchasing from investors who were not covered, some smaller investors. So as you said, there are opportunities, and everything's grandfathered. Am I correct? So that if an entity wanted to buy homes during the next 180 days before January, those would be grandfathered in as well. So perhaps that might be an opportunity to grow your portfolio. Am I thinking about that the right way?
For sure. I mean, if you have access to capital, if you have the ability on the build to rent front, if you have the ability to buy land, and you can build those properties quickly, I think there's a lot of opportunity out there. The other thing I'll say about the bill is I've really focused in on, kind of given what I do, focused in on Section 10, which is the investor section. But there's a lot. I mean, if you're a real policy wonk, there's actually a lot of really interesting opportunity in the bill outside of Section 10 that impacts those within the SFR BTR space and those without. And people like Greg have to, they're held to account for everything that's in the bill, and it's a long bill. Whereas again, I kind of spend my time on this one little section. But I think the entire bill, if you can stomach it, if you have the time for it, is worth a read, because there's a lot of interesting opportunity in there. And then lastly, I'll say, because I know we're coming up on time here, I would encourage those of your listeners on the call to not lose sight of policy moving forward, whether it's going to be at the federal level or the state level. We're already hearing there could be a road to housing 2.0. Elizabeth Warren has been making noise about her interest in further tackling this issue, particularly as it involves institutional activity in the single-family rental home space. I don't think this is an issue that is going to go away in Washington, D.C. I think it's going to be impacted by the elections in November, so that's worth watching. And then again, to follow up on some comments earlier, I think there's going to be a lot happening at the state level, both red states and blue states, probably starting in 2027, if not later this year in the fall of 2026, when a lot of states start to pre-file legislation for 27. So I think that's worth keeping an eye on as well.
Thank you for that. And Todd, from a developer standpoint, how do you see the next 6 months before we get to January?
Well, first of all, there's been a lot of attention on BTR, which we like. And we believe that HR 6644 has effectively institutionalized the BTR asset class. So you're talking about 6 months. I want to retreat a little bit and say that back in the 1990s, you had all of these apartment owners, and they were all small apartment owners until about the 2000s, when really multifamily became institutionalized and institutional capital came in and just really started taking over that industry. That's the same thing that's kind of happening right now with BTR. You have all of these small owners, small developers, very fragmented, that are owning and developing BTR product. And we look at that, what this bill has done at least, is it's provided the institutional capital and given them a lot of attention to say, now it's time for us to come in and really start infusing and deploying their capital. For the next 6 months, what should a developer owner be doing in BTR is they should be positioning. They should be positioning themselves where are they going to be, because if they don't get onto this large institutional wave that's going to be coming, they're either going to get bought up, merged, acquired, and something will happen to them, because it's going to get bigger. When the floodgates come, they'll get lost and eaten up.
I love it. Well, I really appreciate everyone's time today. We've talked about some of the operational concerns that we need to focus on, but I love that there's so much positivity about, where we go forward. And it's important to remember that, because it's been a rough year as we've been trying to figure out, do we even have an industry? The good news is we do. And we just have to stay vigilant now and work together as one voice to HUD and to Treasury to make sure that the regulations that will formulate how the Road Act is implemented support our business. So thank you all. And Gregory, thank you for hosting us and bringing us together. I'll hand it back to you to wrap us up.
Thank you, Cheryl. Extremely informative and a lot to unpack in 60 minutes. And thank you to our distinguished panel for bringing real clarity to a complex piece of legislation. If there's one thing to take from this conversation, it's that the Act is a roadmap and BTR is the real winner. It just changes how the work gets done. And that work starts now. Home count reporting, HUD infrastructure, Treasury's regulations, all of this coming before the 180-day clock runs out January 2027. Two quick programming notes before we go. I'll be sitting down with Todd Wood, CEO, Christopher Todd Communities, for a fireside chat at IMN's BTR Dallas on September 9th. And David Howard, Principal, REHA Public Affairs, is leading one of the 3 SFR BTR Executive Forum panels at Blueprint Vegas, September 22nd through 24th. Discounted registration is live now on everresi.com. Please come and connect with us. And stay with us as the real work now begins in earnest. I'm Gregory Frank. Thank you again to Cheryl King. This is Everresi Media. And to all of you, thank you for joining us.